And you were precise about the time at which the various pleadings and heads of argument ought to be filed. So we have, as the evidence leaders, there was an affidavit filed. Not on time, on Saturday. It was 45 minutes late. The evidence leaders responded to that by means of an answering affidavit that was filed according to the schedule.
Was there an explanation, even if informal in the sense of a letter as opposed to perhaps an application for condonation? I've not seen an application for condonation, but at least an informal explanation, say by letter, for example,
Chair,
for their lateness, for Mr. Matlala's lateness.
What I'm advised is that there was a delay in obtaining the signature from Mr. Matlala. We then requested the unsigned version. So what was 45 minutes late was the unsigned version. We don't know why that could not have been provided on time, because it was the unsigned version, with a later to follow. The later signed version came much later in the day. We don't have any further explanation for it, and my learned friend will no doubt have to address the chair on that. But just to put the order of events in context, this is in the context of the ruling. The evidence leaders then filed the answering affidavit, which was due at 10 o'clock on Saturday morning. That was duly filed. The second aspect that we were required to address was heads of argument based on the application. Those heads were due at 6 p.m. on Saturday. They were duly filed at 6 p.m. on Saturday. What we did not receive by the evidence leaders, what we did not receive was the replying affidavit from the representatives for Mr. Matlala, which was also due at 6 p.m. on Saturday. Nor did we receive heads of argument. We've not got an explanation other than a letter, and Chair, if I may take you to that letter. I'm not sure if it's in your correspondence bundle or if it is provided to you separately. It's a letter that was provided on Saturday at 5:05 p.m.
But if it's the letter that, amongst others, says Ms. van den Heever could not attend the consultation, she was not well, and also talking about the replying affidavit and written submissions which were not filed, we have had sight of it.
That's the letter I'm referring to.
Yes.
What we understood from that was that there was still a consultation to take place with their client, and that we would receive the replying affidavit or the heads at some point on Sunday. It never arrived. I must also say that the heads of argument, of course, are not dependent on the consultation with the client. The heads of argument could have been provided. As we sit here, we do not know what the legal basis is for this application, other than broad assertions of the privilege against self-incrimination and what we've seen from the affidavit, that they wish to rely on a challenge that they intend to bring in the pending trial in relation to the chats and the recordings as being unconstitutionally obtained evidence. I'm not going to stray into the merits of our opposition to the application at this point, Chair, because I'm jumping the gun. My learned friend must address you first. All I want to do to begin with is to place in context how we are sitting here before you today, which is we have filed our answering affidavit and heads of argument. We've received nothing from my learned friend. And we've not received a condonation application or a postponement application.
All right, all right.
And I think once my learned friend addresses you on the merits, I can then turn to the merits.
Thank you, Ms. Hassim. Ms. Missy, let me start by correcting myself before you address us. I gave instructions very early this morning that a directive be sent out that in the event that a postponement is not granted, I direct that only 30 minutes of argument will be allocated. I referred to a postponement because of an erroneous recollection of the contents of the letter that Ms. Hassim has just referred to. My memory, which was a lapse, was of the view that that same letter also sought a postponement. My co-commissioners this morning corrected me and said the letter does not seek a postponement. So I thought I should, in case my directive created confusion, just correct myself up front. But I must say this, if we get to the point where the application has to be argued, my directive as to time allocation stands. Let's hear you.
Thank you, Chair. I've considered how I would address the Commission with regards to this, and I deem it important to refer to a folktale that I've often heard in the corporate world. And the story goes that a security guard was once informed that the boss or the CEO of the company has given instructions that before 6 a.m., no one ought to enter the building. And the said CEO, on another day, attempts to enter the building before 6 a.m. And what he's told by the security guard is that, boss, umthetha uvumi. You will not enter here. I was told that you do not enter before 6. It does not matter whether you are the CEO or you are the one that gave the rule. I will not open for you. And I proceed with that because I want the Commission to get a proper understanding upon which the entire team of Mr. Matlala labors under. Correct. One would note, as correctly put before the Commission by Ms. Adila Hassim, that we did endeavor to provide them with an unsigned affidavit 45 minutes late. That's correct. It then took us approximately 3 hours to file our subsequent signed affidavit. Logically, as an individual, a layperson sitting anywhere would wonder to themselves, but if you had an unsigned affidavit and you only needed for your client to consult, make whatever changes you needed to make, why would it possibly take you 3 hours for you to then get a signed affidavit that's commissioned and file it and serve it on the evidence leaders? And that should give you a picture of how difficult it is for you to get access onto the premises, to get driven from your entrance as a visitor all the way into CMEX. When you enter the entrance at CMEX, how long you have to wait to get searched, to complete the forms, for you to then get taken from that point and walk into CMEX, where you also at that point have to wait for somebody to come and take you up to the boardroom that we have fortunately been allocated by management within CMEX. You then are in there, you're not allowed to have your cell phone devices, which in this day and age, that's what we primarily depend on to get access to the internet. With that being said, we would then have to go through the affidavit. You go through the affidavit, you make the changes. You now have to call said individual to come back and to take you guys downstairs for somebody to open the door for you to get out. You are not allowed, and I actually have got a tongue lashing personally by the management of security at CMEX, informing me that I do not understand and cannot comprehend the level of security and risk that I'm putting myself under by wanting to roam around the CMEX prison without somebody there to guard me and to accompany me. I then was taken to another office where I had to wait for somebody to come and take me to walk out to and go to the security with my learned friend, my instructing attorney rather. We then waited approximately 30 minutes to get a ride from CMEX all the way to the gate. We would be able to get access to our phones, get the internet, and for us to then, I apologize for that, and for him to then go and print the affidavit and then come back. That is a process on its own. We then have to start again, request for us to get a pickup to go back to CMEX, follow the whole process, somebody to pick us up as I had explained initially. And that on its own tells you the difficulty under which we have to labor to get an act that would ordinarily take plus minus 35 minutes to get done. But it took us almost double the time. Over and above that, we did indicate to the evidence leaders that we had an issue because our lead counsel, Ms. Van Hever, was the one who was scheduled to go and consult with Mr. Matlala. So on the way there, when they had received the replying affidavit, she was unable to consult. She turned back home. And by the time we were able to speak to her, I couldn't go back in. I'm then further instructed by I'm told by my instructing attorney that even when he arrived, he was not allowed to go and consult where we were allocated to consult previously. He was treated as an ordinary visitor. So all he could do was hand over to Mr. Matlala the answering affidavit rather, and explain to him his understanding of the legal issues and the position that we would take going forward. Mr. Matlala then gave him instructions that he would need to read the replying affidavit, and he wants to consider the limited advice that he has received from the instructing attorney, and that he also wants to hear the position that is being taken by us as counsel. And again, you note, we don't have cell phone devices. He does not have access, rather, to a computer where we could possibly send him an email, and maybe in the evening he could quickly just see what it is that we've said, and maybe then, before we arrive, he would have a position and we could proceed. On Sunday, Ms. van der Heever then gives me instructions to go with our instructing attorney to attend to this consultation with Mr. Matlala. I personally attended to it. I had to grovel with the head of security and beg for him to at least give us 5 minutes to engage with Mr. Matlala so that we would be able to at least give him an idea where we stand, and then hopefully we can get some instructions. Over and above that, while we were at the prison, we then received another affidavit from the evidence leaders, which they intend on using. That same affidavit I had to quickly give to Mr. Matlala to glance through. He didn't even get an opportunity to read it and to give us a position, and we do believe that he has to address it in the replying affidavits at minimum.
Is that other affidavit the one deposed to by the senior investigator, Mr. Dlamini?
That's correct, Chair. That's correct. And so with that being said, the limited time that we had while trying to balance getting information from Mr. Matlala and maintain relationships with the individuals that tomorrow we have to come back again and beg on a Sunday if necessary to give us access to him. We then had to respect the time that they had given us, quickly give him what we gave him, have him glance through the affidavit, at which myself personally I had not read through, and I couldn't even give him an idea of exactly what is being said in the affidavit, except to say it was from the lead investigator and it has to do with a consultation that they heard on an earlier encounter with the evidence leaders, I believe. With that being said, we were unable to get instructions from him. The little information that we got required us to then create a strategy of how we'll move forward and still be efficient. And our conclusion was that the best way to move forward would be for the instructing attorney to go through the docket again, go through the Section 204 affidavit so that he can adequately provide evidence before, rather depose to an affidavit that is correct and properly represents Mr. Matlala. We have not been able to conclude that process, and as a result, we were unable to file our replying affidavit as we had intended to on Sunday, Chair. With that being said, from Saturday, Ms. van der Heever has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now, having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a layperson not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we receive later on, they make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say let's go ahead, without considering the implications that it would have on him. And we beg this commission, humbly so, Chair, to consider all the elements that we consistently have to deal with to try and ensure that we represent Mr. Matlala and also stand before the commission in good faith, that we're given an opportunity to file that replying affidavit, our heads of argument, and as well as a written condemnation application for the late filing. Thank you, Chair.
Thank you, Ms. Missy. Yes.
Chair, just 3 points.
May I
in response.
just raise an issue, Ms. Missy? What the evidence leaders answering affidavit raises is a legal question, or rather what it raises are legal questions, 100%. So I don't understand this issue of agonizing over how, when to consult Mr. Matlala with regard to a replying affidavit. Those are legal questions which would not necessarily have required Mr. Matlala. Those are legal questions that you, as lawyers, should have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulty understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues. But there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Matlala that he was unable to go and obtain from his the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So
that's very peripheral. Those issues about whether Mr. Matlala received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matlala's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
You are free to respond. I'm not a dictator.
No, Chair, I believe what I've set down in terms of the entire process and how we found ourselves here today I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm listening. You may
Chair.
continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued. In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my rather my application for a standout from tomorrow, still that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case laws, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue and the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law and our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no, and what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider, and perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the Commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. van den Heever was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. van den Heever, Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this the process that we have before us this morning? And underlined, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making that perhaps what we could have done in the interim was prepare the heads of arguments to assist the Commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Good morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Sillo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow?
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right. Thank you, Ms. Sillo. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Nisi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously, and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second point...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in a commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's a judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Kumalo have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlana's legal team this weekend. But that's not part of the application that's before the commission today. It's entirely separate. And that should not hold up the argument on the application. Those actually are my submissions. Chair, I think that the commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you, Ms. Hassim.
I'm sorry, Chair. There's one last point that I've forgotten, and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday, and this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlana's legal representatives were abandoning the application. And I say so because last night at 20:51, we received an email from his attorneys. And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing technical difficulties. To avoid any procedural uncertainty, kindly confirm in writing which questions may be asked and which are excluded. This confirmation is necessary to ensure proper management of the record and safeguard procedural fairness. We would appreciate your written response." The response to this letter was as follows. Greetings and salutations, and then please note that until the commissioners rule otherwise, there are no questions relevant to the terms of reference which we treat as being impermissible. So that was the correspondence between the two sides yesterday. It was quite confusing to us what the meaning of this was, because what it suggests is a request for the questions, what questions we intend to pose. From that, we thought that maybe the approach being taken is to proceed on the basis of pose the question and then the privilege will be asserted once questions are posed. And so I think that my learned friend may need to just also clarify that.
Ms. Missy, does the letter mean that the application is abandoned, or what does it mean?
Chair, no, the application is not abandoned. The reason for the email is we're trying to anticipate an instance where the ruling perhaps doesn't go in our way. And Chair, based on the ruling that you would make, then Mr. Matlala would then have to apply the right against self-incrimination as and when the questions come. And I believe the thought process was that when it comes to those topics that he cannot claim privilege over, then what are those topics that we can anticipate an engagement over so we can prepare with regards to that? It was not to indicate in any shape or form to my learned friends that we are abandoning the application.
Yes, I must say that it was a very strange request. One can't quite tell whether the request was for all the questions that are going to be asked to be itemized, which would be something that's unheard of and in fact quite bluntly very strange.
Chair, I do take note of the wording as well, the confusion that would have come from it, but my understanding was that I think the attempt was to ask under which topics are we going to proceed on once the commission has made a ruling with regards to whether we can proceed, or the argument that we make brings the entire process to a halt. Thank you, Chair.
Thank you. May we see counsel outside, please? The application for a postponement to tomorrow is refused. Mr. Matlala's application must be argued at 12 midday today. Let's adjourn and resume at 12 midday.
The first one being that in a perfect world, we would anticipate that you would say, yes, I'm giving you the additional hours and I want those documents. And whether you're prepared or not, tomorrow proceeding. That's when we win and we get our kitty and we walk away. In the instance you rule that no, we are proceeding, our options would be to go off record as his counsel, and he would be without representation, it implies. Given the fact that...
Counsel only or counsel and attorneys?
Counsel and attorneys.
So, or you will no longer be representing him?
That's correct.
Yes, yes.
So that would be the hypothetical scenario that we'd find ourselves in if you decide that you're not willing to give us the additional time to come through prepare tomorrow. Again, I do want to stress the undertaking that we're making, which is that should you decide to rule to give us the additional time, whether Ms. van der Heerwe is here or not, we will be proceeding to argue. Whether you have received the papers or not from us, we will proceed to argue orally with or without the papers.
You say when?
Tomorrow morning.
Tomorrow.
Should you decide to rule in our favor that we should go home and come back tomorrow prepared. What I'm intimating or suggesting is that the scenario you would have is that whether we file the documents or not, we will be proceeding to argue. Thanks, Chairman.
Thank you, thank you.
Ms. Missy, when you say off the record, you mean you withdraw as his legal team?
That's correct.
Would that go for Ms. van der Heerwe as well?
Those are the instructions that I received as well with regards to, so it would be the entire team.
Okay.
Thank you, Commissioner.
Oh, and there was...
There was another team yesterday.
Yeah. When she placed you on record, Ms. van der Heerwe, last time, she said there was another firm of attorneys as well. Are they present here, and do they also withdraw? Because it's not just the people that are sitting behind you as we understood her.
Yes, I actually just realized right now that Mr. Maluleke is and his firm still is part of this team, so they would also withdraw from there. Can it be the entire team, all attorneys and counsel?
That's your instruction from Mr. Matala?
Those are our instructions.
From Mr. Matala?
That's correct, hypothetically speaking. Okay. Yes.
Mr. Maluleke is not with you. Has there been a discussion with him? Because it's important that we don't end up with a situation where, if this eventuality that you're contemplating happens, that we don't end up with a situation where he comes to the commission and said, I never put myself off record. The team that was here on Monday were not speaking for me, and I hadn't spoken to Mr. Matlala. So I think it's very important that we are clear about that.
I'm glad that you raised it, because that could potentially happen, hypothetically speaking. And with that being said, because these are instructions and engagements that we had with Mr. Matlala, and Mr. Maluleke is not here in person, I suppose then, in fairness to him, he has not commented on that element. These are just instructions. That the entire team would be off record. But I suppose in that instance would have to engage with him and consider his stance should we find ourselves
and it had to be put, it had to be dragged to you, in my opinion, for you to say, yeah, we had an engagement. So there are topics.
Accept that.
I do not accept to get right inside the cracks of the matter, which
A firm declaration or to appear before the commission to give evidence or to produce any document in his or her possession or under his or her control which has a bearing on the matter being investigated, and such person may be examined by the chairperson or an evidence leader. That's regulation 10 sub 6. I'll take it further and reference the rules which at Rule 10, call for documents. At 10.3, the rule provides that should a person claim that a document referred to in the summons, which is the document required, is subject to legal professional privilege, they must, 1, identify the document in respect of which privilege is claimed, and 2, explain the basis for the claim of privilege in relation to each document. The remainder of that rule then deals with the questions of confidentiality and, of course, confirm the chairperson's discretion to determine that certain portions of such document or the document in its entirety is subject to a claim of confidentiality, which claim will be upheld by the chairperson. That's at the chairperson's discretion. Based, therefore, Chair, on Regulation 10.6, we would request that the commissioner's rule, the chair rule, that Mr. Matala, and by extension, of course, his legal team, make available to the evidence leaders and the commission, purely because Mr. Matala, at every turn and in response to every question, invokes the Section 204 statement or affidavit to make available both those documents for consideration by this commission, to determine the extent to which the contents thereof are relevant to the matters before the commission. Thank you, Chair.
Ms. Silo, I'm loath to make such a ruling without full written argument on the point. I'm not sitting here. I'm not altogether sure how Section 105A10A should be interpreted for purposes of whether this commission can, regardless of the nullity, have access to and use the affidavit that was produced in the context of the plea bargain proceedings. Sitting here now, I'm loath to right away make that kind of ruling. I would have to be addressed fully and with written submissions on the point. I was making a slightly different point when I engaged Ms. Missy right at the end before the adjournment. I was saying we got to the point that raised the question of whether this commission should have access to that 204 statement. We got to that because Mr. Matlala chose blanketly to rely on that statement to assert the privilege. And the point I was making was the proper approach for Mr. Matlala is, in accordance with paragraph 109 of the Constitutional Court judgment, to refer to a specific crime, the paragraph says so, and say because of that specific crime, this is how that question impinges on my privilege, and therefore I assert the privilege. For that purpose, he ought not to rely on the fact that he has made a 204 statement, because that doesn't specify the crime on the basis of which he is asserting the privilege. So it is that's why I said we ought not and we should not have reached the stage which we reached. We reached it because of the blanket manner in which Mr. Matala kept referring to the 204 statement. We should not get there. I would suggest that between now and the time that we adjourn, you put your questions again. And Mr. Matala, I repeat, and this was the purpose of the adjournment, I repeat that I will not accept blanket references to your 204 statement, because the 204 statement is not in and of itself a specified or specific crime, a specific crime for purposes of the judgment that I have referred to, and which is authority on how and under what circumstances you can assert the privilege. So do not again blanketly refer us to your 204 statement. Tell us the crime and then claim your privilege. So for now, let's just proceed with your questions on the basis that I will hear nothing of this blanket reliance on the Section 204 statement. And if you insist that we should have sight of that statement or affidavit, I will insist on being furnished with written submissions by both sides on that issue, Mr. Silo.
I accept that, Chair, if I may, with your leave extended. Much as you say, Mr. Matala, in refusing to answer a specific question posed to him, must specify the offense, which is what section, paragraph 109 of the Zuma judgment tells us. Equally so, the point I sought to make and the purpose for which we played that clip is that very document is null and void in the very criminal trial that he is currently facing. So he can't invoke it for purposes of a fear that it will prejudice him in those proceedings. So he can raise that as well.
Yeah. I hear you.
Thank you, Chair.
I think that's a valid point. Yeah,
thank you.
I hear you. Thank you.
So then, Mr. Matala.
I hope because when we took the break, Ms. Missy, that was the point on which I was engaging you. That is, I will have none of this thing, of this blanket reliance on the Section 204 statement. That's when you and your junior engaged each other, and when I said, let's rather take an adjournment rather than watch you engaging with each other. So I hope you did engage Mr. Matala on the point, which is the point I raised with you specifically, and that Mr. Matala now understands that he cannot in a blanket fashion just say, because this was in my statement. But in any event, Ms. Silo makes a valid point, which is that the fact that it's in that statement can't be used against him in the criminal proceedings anyway. I'm just expressing a hope that this was discussed fully. I hope I'm not inviting a debate.
No, Chairperson, you're not inviting a debate. I can confirm that we did impress on him and explain to him why you're taking issue with it with regards to the blanket statement. And so I do hope that moving forward, he'll be able to answer you as per that issue.
Thank you. And Mr. Matlala, the point I'm making applies across the board, actually. It's not just about the Section 204 statement. It applies to any and every issue that may arise upon, or rather, based on the questions that you are going to face from Ms. Sidlo. So you cannot, in very broad and generalized terms, say that's going to incriminate you. We should know what the crime is, and then based on that and looking at the question, see whether indeed your asserting the privilege is warranted under those circumstances.
Thank you, Chair.
Yes, Ms. Silva.
I take it, Mr. Matlala. Did you want to say something, Mr. Matlala? You looked at the chair like...
Yes. If you want to respond, you may, Mr. Matlala.
No, I actually acknowledge what you were saying. There's nothing more.
Okay. Then how we got here, Mr. Matlala, was we were engaged on your third, fourth, whatever, incident where you met with General Sibia and you said that he had invited you to discuss the kidnapping of Mr. Bushoha. You then suggested that you cannot go in any further detail as to that engagement, and for that purpose you relied on Section 204 statement. So now it says you can't, not in the manner that you choose to, because in any event that statement itself has become null and void. So then I repose my question. Can you briefly state to the commissioners the nature of the engagement you had with Advocate Sibia, General Sibia, about the kidnapping of Mr. Bushoha? My apologies, General Sibia.
I think on that issue, I already said that he asked me what do I know about it, or you want me to explain what did I say to, after he asked me what did I know about this kidnapping, do you want me to explain what did I say to him?
Yes.
Okay. Yes, he started by asking me that why are they accusing me actually of that crime? And I took him back and I explained to him that as soon as Jerry's was kidnapped, I suspected two things. The first one was I went to Jerry's house together with Jerry's brother, and then Jerry's brother said to me, I must ask Jerry's wife to give me Jerry's cell phone, because should she find out that there is Jerry's side chick's number in that phone, she will go crazy. And then she said I must lie to her and say this phone is going for investigation. And I did that. That's the first point. So the second one is I told Jerry's wife and Jerry's brother that why don't we tell the police exactly what was Jerry doing, so that at least when they looking for him, they will know which direction to look for. And then I think those two things might have triggered what Jerry's wife did to end up saying, I kept Jerry at my house, which is not true anyway. So, but those are the things that I discussed with General Sibia.
And are you able to say what was the outcome of that engagement? Because it's not clear whether he was talking to you or with you in his capacity as an investigator, having taken over the investigation, or purely as a senior police officer where others are investigating that kidnapping.
What he said to me is, he said to me that if he can crack that case, it will help him a lot. So I will assume that he was doing that as a police officer, obviously, because if he wanted to be the one maybe to crack that case, then he wanted to know what do I know about it, since Jerry was my friend.
And I think earlier I asked whether after that engagement you had any further interaction with him about this matter.
The kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Now, you recall that we were dealing with these issues because paragraph 2.2.3 and 2.2.4 had inquired of you the nature, extent, and frequency of communications and physical meetings with General Sibia. We had said this perhaps is about your third encounter with him. When next did you meet with him, and for what purpose?
The other encounter, I said, is the one that I do not want to talk about it because I'm being charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they also investigating him on that matter. So,
please say the last bit again. And also,
the investigators, they are also investigating him. Firstly, I'm describing the crime. So yes. I said I'm being charged with corruption.
Is this in the Pretoria case?
The Medicare, yes.
The Medicare case?
Yes.
Oh, this is corruption in the Medicare contract?
Yes.
Is it part of the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
So you then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibia.
That is correct.
And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want to say things that
Okay.
will end up making my trial difficult for me. Well, basically, what I'm saying is it will infringe my fair trial rights.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call the Medicare.
Yes.
Because corruption is one of the offenses you
Yes.
are charged with.
Is this the IDEC investigation?
Yes, that's correct.
And this would relate to your interaction with General Sibia. You may disclose something, you say, that would compromise your defense against the corruption charge if you were to speak about this fourth interaction with General Sibia.
That's correct.
Okay. And thereafter, any other?
There's two occasions, but both is the same corruption charge, yes. I'm not mentioning when I went to see him in his office for the Jerebo Shoha issue and also for the public works hospital lease.
So, if I understand you correctly, after your engagement regarding the kidnapping of Mr. Bushoka, you met with General Sibia 3 more times.
Commissioner, I'm just saying, on top, I cannot guarantee that it's 2 or 3. I'm just saying from the top of my head, I'm not sure about that.
And where's my 3? You had said, I said, when was the next time you met? And then you brought up the corruption case in Medicare. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
No, I said except the 2 other occasions when
Oh, okay.
we met in his office. 3 occasions, actually.
So now you had this interaction that could potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with him.
There is no next time.
Was that the last interaction you had with him?
Yes, the last interaction is, I think, is what is it? That engagement party. I don't think there was after that. I don't recall.
So the next time you met with him thereafter, to your recollection, was perhaps the engagement party you referenced earlier. You have to verbalize your answer.
Yes, I said that. Commissioner.
Don't nod, Mr. Matlala.
I'm sorry.
Thank you.
The recording doesn't see a nod. And since the engagement party and the interaction at the engagement party, have you had any meetings, physical or other, otherwise communications with General Sibia?
No, I've never.
When was this engagement party, to your recollection?
Sometime in 2024.
So you said, okay, you can use the season, winter, summer, I'm trying to.
I think it was towards the end of winter, if I'm not wrong.
So I can say mid-year 2024.
July, maybe July, somewhere
Okay.
there.
Did the other witnesses not say it was 14 September?
No, I'm not sure, Commissioner. I'm not saying that. I'm just.
There's confirmation that, yes, the
Yeah.
other witnesses so said.
He might be right. I'm not.
Okay.
I'm not saying that is the truth.
So then I'll accept that. The last engagement you had with, or interaction you had with him was at the engagement party in 2024, whatever the actual date was.
Not the last. The timelines, I'm a bit confused with them.
Yes.
But it's one of the interactions, yes.
Okay, then let's get past the engagement party. When did you next engage and interact? After, now we have the engagement party in our minds. I trust fund was heard by all, so after that, when did you next engage?
What I can remember is our own.
Sorry to do this.
Yes, Commissioner.
There's confusion about the third and fourth occasion. If the engagement party was in September
Yes.
and the raid was on the 6th of December, then it must mean the engagement party is the third occasion and the raid is the fourth occasion, because December comes after September.
Indeed. Do you understand?
No, I understand, yes.
Yes. Remember we discussed the kidnapping of Mr. Bushoha?
Yes, yeah.
And you said it was after the raid.
Yes.
So the commissioners point out to us that the order of things is not right. The engagement must have come before your engagement with him regarding Mr. Bushoha, because that was only after the 6th of December.
Of course, yes, I agree.
So we should swap the dates around.
Yes.
You said yes.
Yes,
Oh, you're still thinking. I don't know.
I'm thinking.
I don't want to rush you.
I'm trying to remember. I think, if I'm not wrong, I also met him in 2025. So I'm trying to remember while you're speaking. I'm sorry. So I mean, I was trying to get the exact date.
Then perhaps if we say, while we correct that you then met him next in 2025, perhaps if we discuss the circumstances of that meeting and what was discussed, that would help us sort out the order of things, hopefully. So what did you, in 2025 when you met, what was it about and where, and how did it come about?
Commissioner, I'm saying I think I met him in 2025. I'm not certain, but judging by the timelines, because after the raid, I remember I didn't have, there was no way after the raid, first, I'll say maybe 15 days, there was no way that I could have seen him because I was busy with police and then I was busy with my meeting with, so it must be maybe January, I think.
Oh, okay, I think I get you now.
I'm trying to have a proper recollection, so.
And is that in relation to the discussion around the kidnapping of Mr. Bushoha? That's the one you're putting it around January 2025, am I understanding you correctly?
Yes.
Okay. So then, after the Mr. Bushoha discussion with him, when you would have met again?
I don't think I've met him again after.
Since?
Yes.
Have you ever communicated with him directly or via Sergeant Ngosi?
Communication, yeah, I think there was a communication via Sergeant Ngosi, yes.
Are you able to just highlight what the communications was about and who had initiated such communication? And if they are different, then you can enumerate each and talk about who had initiated and what each communication was about.
The communication was through all the time was through Sergeant Nkosi.
But at whose instance?
If I remember well, the communication was regarding after the raid, why did I tell the police that I know him? So, I think it should be in December. After the raid, maybe before January, I think there was a communication.
Okay.
I'm just confused. I'm not.
Okay.
I'm sorry. I am not.
Are you now referring, remember there were 2 raids in December. There was a raid at your house
Yes.
where the police were looking for Mr. Bushoka.